Good afternoon, everyone. So we are back with yet another webinar looking at the impact of the labor codes. So if you recall, we've already done 3 deep dive webinars where we've talked about code on wages, the rule around code on wages. Now we are back with the 3 new labor codes that have been just announced. So we look forward to an engaging session for the next 90 minutes. My co-presenter, as always, my partner in crime is Puneet Gupta, and we will talk about what we see as unfolding in this whole saga of the new labor codes, the central government labor law reforms that are being kind of a journey that's been started. With this, let's look at what we are covering today. We will talk about, give you an overview of the codes, talk about what are the laws that are getting subsumed into these 4 labor codes. We'll talk about the positive sides of these codes, and then just get into a deep dive on the key aspects of these codes. We will look at it from the lens of what's an employee versus a worker, because this is a big question around applicability of laws. Many people have asked us whether these labor codes are applicable to all employers and all employees. We'll spend time talking about it. We'll talk about the definition of wages and how it is changing and making employers worry about the increase in the cost of employee benefits. We'll do some practical examples around gratuity, bonus, and Provident Fund calculations, how that they may be impacted. We'll then get into working hours and a very controversial topic around overtime, wherein employers now from the current reading of the draft may have to really worry about giving overtime even to managerial level employees. This may just be an interpretation, but we want to spend time talking about it and how we are thinking through this. Then go on to talk about contracted employees, how compliance around contracted employees may undergo a change, what an organization probably needs to do to be ready with it. Then the overall compliance around the new labor codes. There are no judicial precedents. This is a new framework. Yes, a lot of these provisions may be old wine in a new bottle, yet there is a new framework. There are new things that have come in which may have far-reaching impact, and therefore we'll talk about what an organization needs to do in order to be ready for compliance. Then also talk to you about what is the government's plan around enforcement of labor laws, which hitherto where we've seen tardy compliance. Then let's look at the way forward for an organization as it prepares itself to implement these labor codes. Okay. So if I look at it on the labor codes, really an accelerated journey that we've seen in the last 1 month. Code on Wages 2019, as you know, was enacted law in August 2019 itself. And towards finalization or putting it into force, the government issued draft rules in July 2020, which got open to public comments. And as EY, we filed our representations, talked about what we see as possible challenges. And many of you who've been attending our webinars and private meetings we've been having know about the challenges that we put forth before the government. Hopefully, they will get addressed as the rules are finalized. Then, a few weeks ago, if we had, we'd been asked this question about what is imminent, one would have only spoken about code and wages to 2019. But the whole story changed in the last 1 month, where the government came out in the press talking about all 4 codes, and as much as giving even a time plan to say that the rules for the other 3 codes will be out in November. First, we heard about implementation in December, but that perhaps was too ambitious. Now we have a sort of a announcement that labor codes will be applicable from 1st April 2021. So there's lots to be done. As we stand today, the status is all 4 codes have gone through both houses of parliament, have had the requisite presidential assent, now are awaiting date of entry into force to be laws in action. For the 3 labor codes which came in last month, the rules also have to be, draft rules also have to be issued. And once the final rules for all the 4 codes are notified and the date of entry into force is also notified, these will be applicable laws which every organization will be bound with. Okay. So when I look at the labor codes and, as we've been talking about 29 central labor laws being subsumed into these 4 codes, let's spend a little time on what these laws are that are getting implemented or subsumed to bring in the new labor code. The Code on Wages 2019 has 4 very relevant laws that are getting compressed into it. We have the Equal Remuneration Act of 1976, the Minimum Wages Act of 1948, the Payment of Wages Act 1936, and the Payment of Bonus Act 1965. The reason why I want to be able to even read out these names is for you to understand these are laws that are applicable to every organization. They impact on how much you pay your people, how much you pay your employees. Do you make any differentiation between men and women? What is the timing of the payment of wages? What deductions are permissible? How much and to whom you pay bonus, statutory bonus? All of these laws will now be governed by Code on Wages 2019. As I said, it could seem that a lot of these are, provisions that already existed either in the Shops and Establishment Act or in some other applicable law or maybe Minimum Wages Act. Maybe these provisions were there. But wherever the tweaks have happened, wherever the changes have happened, they have been made in such a manner that suddenly you would think that there is far more reach of these codes than the laws that would have been there earlier. So applicability to all employers and all employees is an area that one would have to see. Otherwise, may have thought of these as laws impacting only a certain category of workers or with certain wage thresholds. But that's set to change with the new labor code. So if I want to talk about the minimum wages law, the concept of floor wages at a national level has been introduced. So the state governments would have to now redo their minimum wages to make sure that they are in line with the national floor wages as notified by the central government. The timing of payment of wages is also very critical in terms of when you should pay, when should you pay employees hired through a contractor, in terms of the deductions that are permissible, the timing of full and final settlement of employees who even voluntarily resign. Hitherto, yes, we had the condition of 2 days in case of people who are being retrenched or asked to leave of full and final settlement. But now, with voluntary resignation, the condition of ensuring that full and final settlement happens within 2 days. And in many of our discussions we've already had with our clients, we've heard the concern around how do you ensure that. So in terms of bringing a change in the normal working day, 8 hours of work and 1 hour of rest, and not giving employers a flexibility. Then the other thing which I said we will go into more detail about is the overtime pay, which is coming in, and we will talk to you how we think that overtime pay could, as the current reading and the verbiage of the law, could be applicable to all. It also, when you look at code and wages, some of the other things that one would worry about is the fact that there is a cap of 50% on deduction from an employee's salary. So this and many other things that are possibly key aspects of the Code on Wages 2019. When I look at the Code on Social Security 2020, as you can see, it has some very major laws that are getting subsumed and covering aspects of Provident Fund, gratuity, maternity benefit, and many other sector and industry-specific laws are also getting subsumed. For most of these laws, while the current framework, such as for the 3 schemes under Provident Fund, for Provident Fund, pension, and EDLI, it's the same as before. Yet the changes that may come in would increase cost. So whether the question on everybody's mind is whether the wage ceiling will continue. Today, as you understand, there is a basic wage ceiling for people who are first time joining the workforce, whether or not they should participate in the Provident Fund scheme, whether that is set to go away, and keeping in mind the larger objective of ensuring social security for all, would all employees be covered under Social Security Code? Whether the calculation for Provident Fund will change. We've had a sea change in the whole calculation of Provident Fund with the Vidya Mandir case in Supreme Court decision in February 2019. Now again, would that definition will need further change? So some of these things, will be addressed in the Code on Social Security 2020. Then looking at the Occupational Safety, Health and Working Conditions Code 2020, we did get questions where organizations wondered why should we be talking about it, because if you're not a factory, why should one bother about it? But the way the current provisions read, it seems to suggest that it could very much be applicable to all employers. So whether you are a manufacturing company where you were already covered because of the Factories Act, but if you are an IT services company or a pure services sector company, you would end up getting covered in the new Occupational Safety, Health and Working Conditions Code 2020. Essentially, they're making it every employer's obligation to worry about the employee's health and well-being, and therefore the prescriptive conditions around maintaining in compliance around Occupational Safety, Health and Working Conditions Code 2020. Then the fourth code, so the Industrial Relations Code 2020, which will subsume the Industrial Disputes Act, the Industrial Employment Standing Orders Act 1946, and the Trade Unions Act of 1926. So this is one where you would have, say, while it's applicable to all, but it just has more relevance in case of workers. And we'll touch upon this as we talk about the difference between an employee and a worker. If I look at it, from a positive stroke standpoint, what is good and which is very evident is simply the reduction in number of laws from 29 to 4. So if you were following the slide previously, we had listed out 29 central government labor laws which are getting replaced by 4 codes. So well done in terms of achieving the objective of reducing the multiplicity of laws. When you look at it from a perspective of common definitions and terminology, earlier something like wages had 12 different definitions in the 29 laws. Now, with a single definition across all 4 codes, one hopes for greater consistency. Whether or not that definition itself will have its own set of challenges, that we will see, but at least there's one single definition. Reduction in number of registrations from 8 to 1. Then the other thing that was about where trade unions really were upset about the approval requirement for an establishment which it had employed 100 people for if they had any plan for retrenchment, they needed to get a central government approval. What they've done is that this would now be applicable in case of an establishment which has 300 or more workers. So that's changed from a worker perspective that this is coming in, not seen as a very worker-friendly provision, but yet the purpose of simplicity and ease of doing business. Then a big change with these labor codes, very much in keeping with the commitment that our country has enshrined in the Constitution, which is about India being a welfare state, and also reiterated in the political manifesto of the present government. We see the suggestion of Social Security for all. The new thing, hitherto Social Security or gratuity was applicable only in case of people who work 4 years plus 240 days as the case is. Now, in case of even fixed-term employment, so the difference between employment at will and fixed-term employment contracts, there is likely gratuity that would be payable. There is a bit of confusion whether it would be payable irrespective of the number of years or the period of, part of the year if it is an employee who works under a fixed-term employment. Will it always be applicable? Because there is a conflict between code on wages and the Occupational Safety, Health and Working Conditions Code. But we'll talk about that. They're also bringing within the ambit of Social Security gig workers, platform workers, self-employed workers, and unorganized workers. So definitely a big positive stroke, taking into consideration equity as an objective for all the 4 labor codes. Protection of employee benefits, trying to reduce the number of informal work arrangements by insistence that employer must issue an employment contract or an appointment letter to all employees within 3 months of being hired. Now, there's also something that when we were reading through the provisions, Puneet and I were wondering about this annual health checkup for employees, whether it is for all employees or for a certain category of employees, it will need to be clarified. So floor wages to be notified by the central government, as I mentioned, this is a sort of a national high where, even in our federal structure, using its powers as a lawmaker under the concurrent list for labor laws, government is setting up a basic threshold for minimum wages. Then they've introduced some relief for smaller businesses, increasing the number of employees if you are to be covered under Factories Act. So that means your coverage under Occupational Safety, Health and Working Conditions will therefore be differently dealt with. There's a different threshold that is coming in. Similarly, for some of these provisions relating to contractors being applicable, you need to have the number goes up to 50 from the existing 20. Then the applicability of standing orders. So this is more from a perspective of IR really, that you're looking at it for the IR, the industrial relations codes, different businesses, the applicability goes up depending on the number of employees. Then a big change. Now, we've always said that Indian labor landscape, has not been really very positive because compliance has been more informal than formal. Businesses have feared the arrival of the labor inspector or anyone who would be trying to sort of seen as not kind of enforcing it appropriately. This is what has changed with the proposed labor codes, where automation is coming in. There is introduction of some of these international best practices like the inspector come facilitator, sort of the random web-based inspection system. And one big thing which we've been waiting for some time, there were circulars around it, where now they've brought in a statute of limitation for initiation of proceedings under Provident Fund and ESI. So it is a 5-year limit that has been brought in. Okay. Now I think, so this is where I wanted to give you a flavor. A lot of it probably, if you attended our webinars earlier, may seem like a bit of a repetition, but I wanted to set the context of what these labor codes are about. And the conversation is getting more and more intense because while the final rules on code and wages are awaited, the other draft rules are expected. So, the ability to influence some of the lawmakers around this is what we've been using by filing our representation and talking about it. So let me, at this stage, start to address the questions, and my co-presenter has been waiting his turn, so let me bring in and get him his glory under the sun. So essentially, let's answer the sort of the elephant in the room. We've got this question many times, haven't we, Puneet, where yes, clients have said, why should I worry about these labor codes? A, the legislation itself has taken years, from 2002 when Prime Minister Vajpayee first started till 2019, we didn't know what this was, where it was languishing. Suddenly, you've got these 4 labor codes. But, these are central government labor laws. Why should I worry? State governments haven't got their acts together. So what are we going to do? Then, is it really applicable to me? It's applicable to low-income wage earners. I only have employees who have a salary much beyond the threshold. So is this the question really that kind of keeps coming back to us is, are the central labor codes applicable to all employers and all employees? And I'm supplying the emphasis here, both all employers and all employees. Over to you.
Yeah. So Sonu, I'll get into details, but if I were to just answer this in just a couple of words, yes, it is. These codes are applicable to all employers and all employees. So it won't matter whether you are in a top-level management guy or you are middle-level management or a low-wage earner or a factory worker. The codes, most provisions of the codes, barring a few exceptions, and we'll talk about the exceptions, are applicable to all employers and all employees. Now, what they've done very differently from anything we've seen earlier under the laws, they have these 2 definitions under the 4 codes, one of an employee and second of a worker. Now, most provisions in these codes, like all the 4 codes, most provisions apply to an employee, but there are certain provisions which are only applicable to a worker. So before going into the impact of these definitions, let's understand who's an employee and who's a worker. Now, if you were to simplify it, a definition of employee is a much broad-based definition, and it covers almost everyone employed by an organization. So whether you have someone doing skilled, semi-skilled, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical work, everyone is covered under definition of employee. So I can't think of any role in an organization where someone can say, oh, this is not an employee, because it really covers everyone.
So what you're saying, Puneet, is the definition of employee per se has become much more broad-based.
Yes.
And they're not cutting it between employee and worker. Employee seems to be an omnibus definition which subsumes a worker as well.
Yes. Irrespective the role, irrespective the level, irrespective the nature of duty, irrespective the band, irrespective the salary limit, whether you're in a 1 lakh salary bracket or a 1 crore salary bracket, everyone is covered under employee. Now let's look at the second definition. the worker. Now, this definition, in fact, is very similar to the definition of workmen under the current Industrial Disputes Act. And the definition has two parts. One, it's first trying to cover most roles, but then what is important and critical to note is the list of exclusions. So the definition of worker does not include any person, A, who's in a managerial or an administrative role. So anyone having managerial duties is not a worker. Second, anyone employed in a supervisory capacity drawing wages exceeding 15,000 rupees or 18,000 rupees per month or at any amount notified by the government. Now, you'll wonder why I'm quoting these two amounts, 15,000 and 18,000. What they've done is under the Code on Wages, which was earlier issued, which was earlier notified last year, they've kept the limit as 15,000. Under the three new codes that are notified recently, they've kept the limit as 18,000. So therefore, you see those two numbers differently there. But really what it means is any individual who is in a managerial role, administrative role, or a supervisory role is therefore not a worker. He is still an employee, but he is not a worker. And like I said, most provisions of these codes apply to an employee and therefore apply to everyone and not just worker. And that's really the big change. Now the question that you'll ask is, okay, then who is in a manager? Who is someone in an administrative role? Who is someone in a supervisory role? Now, unfortunately, these terms were never defined earlier under the Industrial Disputes Act and have not been defined under the Code on Wages or the other three codes. So therefore, we go by general interpretation and various judicial precedents on it, and the below-trough rulings on who's a manager and who's a supervisor. The important thing, very, very important thing to note is that the definition of worker is not just applicable to a factory. Even in a service industry, an IT company, if you have employees at base level who are not managers and who are not supervisors, they are workers. And like I said, there is no definition of these terms. What is important again is multiple courts have held that you don't decide whether a person has managerial duties or supervisory duties just by his title. So if say someone is called an assistant manager, doesn't mean that the person necessarily has managerial duties. So it's not the title which is relevant, it's the nature of duties. The primary purpose for which that individual is hired will determine whether or not that person has managerial or administrative duties. So I think one very important step that organizations need to do is to really decide whether individuals hired by them are employees or workers, because the application of these codes could be very different. Most provisions, like I said, are applicable to employees, but there are some which are applicable only to workers.
This is a big thing you're saying, because every organization will have a lot of employees who do not have any managerial or supervisory duties. It could be, analysts, people working at the bottom of the pyramid really, who don't have any sort of managerial or supervisory duty. So potentially we are saying that category of employee could be considered as a worker and may attract additional compliance.
Absolutely, yes, without a doubt.
Okay.
Okay, moving on. Why is this relevant? So let me give you a few examples and why we are saying the coverage of these labor laws is much broad-based and they have wider applicability. Now, let's look at the Code on Wages. The Code on Wages covers minimum wages. If you read the definition of a worker or an employee under the current Minimum Wage Act, definitely non-managerial staff are covered, but managerial roles are not covered under the current Minimum Wage Act. And then it also is only applicable to scheduled employment. While now, minimum wage provisions under the Code on Wages are applicable to all employers and all employees. I'll give you a second example, payment of wages. Earlier, only covered employees with salary less than 24,000 rupees per month. Again, now applicable to all employers, all employees. Provident Fund. Earlier, someone drawing salary more than 15,000 and joining workforce had an option of opting out. That option of opting out is no longer available. Even for an employer's perspective, earlier, there were scheduled employments. Most companies were still covered, but there were exceptions where, say, banks were not covered under PF law earlier. Now, again, it's applicable to all employers, all employees. And then we see these special provisions now brought in for fixed-term employees, gig workers, platform workers, self-employed workers. Sonu, you touched upon Factories Act earlier, where under a central law, you had obligations that an employer has towards health, safety, well-being of an employee. Earlier only covered mostly for factories. now applicable to all. Even an IT company or a service company needs to ensure that they comply with those obligations towards employees for health, safety, well-being. Working hours and overtime. So though there are special provisions for working hours and overtime and leave encashment, and I'll touch upon that later. Special provisions only for workers under Occupational Safety Code. That's one exception. The second exception is Industrial Relations Code. The entire IR code is only applicable to a worker. So anything to do with industrial disputes or standing orders or trade unions, those provisions only apply to worker.
So if I can summarize, Mohit, what you're saying is Code on Wages 2019 and Code on Social Security 2020 is applicable to all employees. Parts of the Occupational Safety, Health and Working Conditions Code 2020, which deal with employee health, safety and well-being, are applicable to all employees. But then there are provisions of this OSH code and the Industrial Relations Code, they apply to workers and not to employees. So clearly, Industrial Relations Code is applicable to workers, while OSOH, which is a new development, because we traditionally thought the Factories Act, as the name itself said, only applicable to factories. Remember, the Factories Act is getting subsumed into the Occupational Safety, Health and Working Conditions Code 2020. Parts of that code now being applicable to all businesses. So that's something that people should be looking to watch out for. Moving on, let's look at what's the new definition of wages. So, how is it going to be different from the current law? What is changing? I talked about the fact that we had multiple versions of this one term wages. Let's just go deep dive into it.
Sure. Now again, before we cover the impact of this definition, let's again look at this, my favorite definition of wages these days. The good part is that they now have one definition, right? From compared to 12 different definitions earlier, companies only have to look at structures and have to look at only one definition of wages. The not so good part is the definition is not as simple as we would have wanted it to be, and it has its own peculiarities and challenges, and we'll address some of those as we go along. Now, if I can divide the definition into three main parts really. The first part of the definition covers all salary components expressed in terms of money or capable of being expressed, and then definitely includes basic pay, dearness allowance, retaining allowance. But I will stress on the initial words, which is all salary components expressed in terms of money or capable of being expressed in terms of money. So really, whether you pay an employee basic salary or any allowance by whatever name called, or reimbursements or benefits, everything is covered under the definition of wage. And that's a big change, because currently if you look at the definition of basic wage under PF law, it only covers cash emoluments. But now here they're very categorically putting out that it covers all salary components. That's the first part. The second and the very important part of the definition is a list of exclusions. What they've done under the code, they have provided a complete list of exclusions, prescriptive list. All those components are excluded from the definition. And if I were to just categorize for the sake of understanding, categorize those exclusions, I can again categorize those exclusions into three parts. The first part is regular components like bonus payable under any law. Mind you, this is bonus payable under any law, which is only statutory bonus. It does not cover performance bonus. Conveyance allowance, house rent allowance, overtime allowance, commission. So regular components. Any allowance other than this allowance is now covered under definition of wage. So all your special allowance and other allowance are now covered. The second list is benefits that are excluded. So house and accommodation, light, water, medical attendance, value of travel concessions, so LTC or an LTA. Very important, amenities or services excluded by general or special order of the appropriate government. And appropriate government is defined as the respective state government. What they've done is they're now allowing state governments to prescribe lists of amenities or services that can be excluded from the definition of wages. And those orders from the relevant state governments can be general, which is applicable to the entire state, or it could be special, which is applicable to a class of establishments or a particular establishment. So while the definition is one, but the applicability of the definition in different states can still be very different. And then they've excluded any sum paid to defray special expenses, which again can be a big issue on what is covered there. Then they've excluded certain retirals like contribution to PF and pension, remuneration payable under any award or settlement, gratuity and retrenchment compensation. Now, if I were to see the first part and second part of this definition together, what it really means is anything and everything, whether basic salary or allowance or benefit or reimbursement, other than the specific exclusions, are now covered under the definition of wage. And this is common definition applicable for all purposes. So all your retirement benefits now get calculated on this definition. And then the third part, they put in a limit on exclusion. A company cannot say, okay, I'll keep conveyance and HR as 80% of CTC and therefore can exclude 80%. No, that's not possible because the maximum you can exclude total of all of this. There are no separate limits for HRA, bonus, commission, etc. An overall cap of 50% for exclusions on the total remuneration. The exclusions, the cap does not cover gratuity and retrenchment compensation because those are only paid one time when employee terminates. But other than that, on a month-on-month basis, the total exclusion can be 50% and not more. So those are the three parts of the definition. Everything's covered, subject to exclusions, specific exclusions, and the total of those exclusions cannot be more than 50%. And then they're saying they've also added this last line in the definition, which is actually the most complex part of the definition, where they're saying remuneration in kind to the extent it does not exceed 15% of the total wages shall deem to be included. Now, what is remuneration in kind is a big issue. There is a school of thought that it only covers plantations or agriculture sector where you actually pay remuneration in kind, and therefore it would not apply, say, to a service industry. But there is that other school of thought that also covers, say, components like car lease and telephone expense reimbursement or meal coupons there, and therefore notional value for those are covered. So that part I will still ambiguous, and some clarity from government is definitely expected. But the three parts of the definition are crystal clear, which will mean two things. One, added cost for company, because now you have a much larger base for calculation of retirement benefits, and I have a few more slides to dwell more into that. And second, lower take home for employees.
So thanks, Puneet. I think this is critical for us to really understand, because it also ensures that a lot of the conversation that follows henceforth in the slides that will come after this, we've also looked at, how wages is being defined in the new codes. The point that Puneet, you talked about, the fact that remuneration in kind being capped, it should not exceed 15% of total wages, will be a problem, because again, remuneration in kind, did they need to go and kind of put it out expressly? Because in the first part of the limb of the definition, they're specifically saying that anything which is money or capable of being expressed in terms of money is wages. And then to go and exclude and carve out a separate category, whether that school of thought which says this is only for plantation workers, there again it's a big problem, because if a lot of your wages are being paid in kind and that's the custom and that's how it is being looked after, then this seems to be something that they should probably need to address. I did mention to you earlier that one of the big things, on this as EY, we've been very actively engaged is the advocacy. So in our representation, we've really asked the regulator here to clarify, what is it that would happen to things like performance bonus, discretionary incentives, variable payouts, employee stock option plans, all these one-time allowances and benefits, because they are, if you look at the definition of wages, they are money or expressed in terms of money. These are clearly wages, and they are not excluded in that prescriptive list. So does that mean that now the employer has to look at these as wages and compute all those benefits that we're talking about? That will be one thing that we therefore need to do. On performance bonus, very expressly, I think what is worrisome, and that's why this clarification from the government will be useful. Performance bonus actually came up in discussion before the Parliamentary Standing Committee. And at that time, I believe the response from Minister of Labour and Employment was that bonus that is given as per Payment of Bonus Act, that is the statutory bonus, is a clear exclusion from the definition of wages. But any other payment, whether you call it bonus or otherwise, it is covered within the definition of wages. So therefore, I think we would want and wait and watch how the government clarifies this, whether through rules, whether through amendment in the codes, it has to be done. Then in our representation, we also, I think, Puneet, I won't repeat, but, some of these benefits around car lease, car fuel, expense reimbursement, whether these kind of get categorized as any special expenses, paid to the employee. Things like meal benefits, telephone and internet expenses today of remote working. These are big payments that the employer is making. So whether these are covered in the definition of wages or to be excluded, club membership, and lots of permutations and combinations are possible if you start looking at what could be the amenities or services. The requirement that you obtain if an employer organization needs to obtain any exemption, it must be obtained from the appropriate government. And mind you, every time they use the word appropriate government, they're talking about the state government in which the business is located. So we could have, same organ and one company with multi-state presence getting different levels of exemptions from different state governments. So I think that's where we hope that this will also be rectified by the central government and not leave the employers to the mercy of the state governments, because each state government will have its own take on it. Then, in addition to excluding gratuity and retrenchment compensation, the 50% cap under the first proviso that we're looking at, again, these are not really any part of fixed monthly salary. So, the point that I was making earlier, they will have to find some way of excluding that. Then, when I look at it in terms of I've covered the bit about the sum paid to defray special expenses. Now, the big thing, the second part of that definition, which says 50% of the total remuneration is allowed as an exclusion or a deduction. Now, this 50% cap, there could be employee who's on, unexplained leave and therefore the reduction is much higher number than the 50% cap. And there's also, by the way, somewhere a requirement to take an approval from the inspector cum facilitator if the deductions are exceeding. Now, if that's the case, there is a problem. So we'll have to, kind of hope that this will be clarified. And as I said, it does form a great part of our advocacy that is ongoing with the government.
So really, while the definition is a good move that there's one definition, but the fact that definition has so many nuances and ambiguities, it is going to be a tough one for companies to really implement. Like you said, Sonu, the fact whether performance bonus is covered or not, whether car leases are covered or not, are big ticket issues that companies really need to take positions on. Because effective first April, if this is going to come in force, then all future retirement calculations have to be done on this definition.
Then we are really saying that this is also opening up the need for restructuring compensation, salary structures, and recalibration of employee benefits, because those are the things that will add up to the CTC or the cost to company of the employee.
I think that's really one big step each company will need to take to ensure the new structure or new salary structure is aligned as close as possible to this new definition, because up until now, normally whenever we've done compensation structuring, it is only from a tax point of view. But now somewhere companies will have to do that balancing between employees' cost versus employers' cost under labor codes. Okay, moving on. What's the impact of new definition of wages on employees' benefits and employers' cost? And maybe we go step at a time. Let's talk about Provident Fund first. Okay, so like Sonu said earlier, for PF, this basically made a provision that the current PF schemes will continue to apply for next 1 year. Will that mean that there is no change in PF? I think one big change they've done is they've now said specifically that the wage ceiling is not applicable for PF coverage. So really, when they defined employee, where earlier, and if they had this specific definition of excluded employee to say anyone drawing salary more than 15,000 had an option of opting out, that option of opting out is not available now. So whether you are on a 15,000 salary or a 15 lakh salary, you're now covered. Everyone is covered under the PF Act, under the PF scheme. So that's on the coverage, PF scheme basically being applicable to all. On contributions, given that they don't have any specific provisions in the code and they specifically said that for next 1 year, at least the current PF schemes will continue to apply. We know currently under the current PF scheme, there is this provision to para 26A, which says that anyone drawing salary more than 15,000 can limit contributions on 15,000. And that provision really has been basis for most companies to limit contributions on basic salary wherever basic salary is more than 15,000. So till the time they don't change the 15,000 cap, a probable interpretation or position could be taken that there is no need to change PF contributions. It may continue very well on 15,000 or the current basic salary if it's more than 15,000. But one big fear that everyone has is that the government will change the 15,000 cap. And that could be done at any point of time because that's just a notification to be issued by Ministry of Labour. It doesn't have to go to the Parliament. So only if there is a change in 15,000 cap for next 1 year, the PF contributions may change. But if that there is no change in the 15,000 cap, then probably for PF we can still take a position for next 1 year. The current PF contributions on basic salary can continue. I think one of the other questions we've routinely been asked by clients is what will happen to this whole Supreme Court ruling around Vivekanand Vidya Mandir, whether that will continue to apply, whether that's no longer applicable. And I think I would want to address that question very specifically because that's a very important point. The Vivekanand Vidya Mandir ruling by the Supreme Court in February last year was basis the current definition of basic wages under the PF Act. That definition and this definition of wage under the Code on Wages and the Code on Social Security are two very different definitions. So the Vivekanand Vidya Mandir ruling will squarely not apply as is to the new definition because it was based on an earlier definition.
And it's also evident, right? Vivekananda Vidya Mandir said conveyance allowance included, and in this they're expressly excluding. So first of all, it's not the same. That was part of one of the laws, which is the Provident Fund. Here it is coming in expressly as a definition which is going through all the four codes.
Yeah.
So I think if I may summarize, Puneet, this particular point, you're saying that Provident Fund likely coverage for all employees. So watch out for that. There is no change in the PF contributions at least for 1 more year because the PF scheme will continue as is. Unless they notify a change in the ceiling separately through a notification. But for now, I think we can rest on that count that for the next 1 year, whatever definition you kind of settle yourself with, you can continue to go with that, but start looking at it as to what awaits if there are changes in this.
Yeah.
Okay, let's move on to the next one, which is around gratuity.
Okay, this also is very interesting. So in terms of employees' eligibility to gratuity, currently, there's this 5-year service threshold. If an employee terminates employment for whatever reason after 5 years of service, then he or she is eligible for gratuity. Under the code, this provision continues for regular employees. In fact, there was a lot of pressure on the government from the Parliamentary Standing Committee to reduce this 5-year threshold to 1 year for regular employees. That has not been done. So for regular employees hired regularly, they're only eligible for gratuity after 5 years of service. Only for fixed term employment, there is a change where they've removed the 5-year cap. So they're saying for fixed term employees, they're eligible for gratuity irrespective of the 5-year cap. Now there's a bit of conflict there between the Industrial Relations Code and the Code on Social Security because Code on Social Security just says that the 5-year cap is not applicable for a fixed term employee. So whether a fixed term employee has worked for 1 month or for 6 months or for 12 months, he or she is eligible for gratuity. But the IR code, when they've defined a fixed term employee for a worker under IR code, they've specifically said eligible for gratuity after 1 year of service.
Could this be an unintended consequence? Because keep in mind that the overall objective is equity. They wouldn't do something to create an imbalance while an employee who's worked for even maybe 6 months being entitled to gratuity, while a worker who's not worked, because the condition of 1 year is coming in the Industrial Relations Code, which is only applicable to a worker. Yeah. So I think this is something that probably will get fixed, but as of now, there is a difference. Yeah.
So just to clarify, for regular employees, the 5-year service threshold continues. They only are eligible for gratuity after 5 years of service. Only for fixed term employees, the 5-year service threshold is not applicable. Now, whether the 1 year limit is applicable for them or not, that's slightly still a gray issue right now because the IR code and Code on Social Security say different things. So that's on the coverage. So more employees are covered for gratuity. On contributions or on payouts, the current employees and employees eligible for gratuity, which is 15 days wages for every completed year of service, subject to a cap of 20 lakhs. Similar provisions are there under the code, so it's still 15 days salary or wages for every completed year of service. There's no 20 lakh cap. That cap has to be notified by the central government. So whether they continue with the 20 lakhs cap or they increase, that again, we don't know for sure right now. What has changed is the definition of wage, where earlier gratuity was calculated only on basic salary. Now it have to be calculated on this new definition of wage. And I think this is the biggest implication, the one big implication on the Social Security Code, because gratuity will now be calculated on total wage, which will be much higher than before.
And the fact that even fixed term employment contract employees will be covered.
Yeah.
So which means that if you have international workers or expats working who come on secondment, who may not be 5 years or 4 year plus condition as is otherwise applicable for gratuity, for whatever be the duration of employment with the Indian entity, now they are clearly going to be eligible for gratuity. So you need to provide for that gratuity, and mind you, given the comp levels at that level is much higher. Comp
levels plus if they're saying performance bonus and some of these benefits in kinds are covered, then it's going to be a very significant impact for companies to bring expats to India.
So this will make some of you start to recalibrate your gratuity provisions, think about what is the likely impact on P&L next year if these codes are going to be applicable from April 2021.
Yeah. So whether you have gratuity plan with LIC or you just make a provision in your books, it's a non-funded plan, or if there's a gratuity trust, in all three situations, companies will have to relook at the impact on P&L, especially the first year, because we keep saying that the codes are going to be prospective. But the fact that even an existing employee, say an employee who's worked with you as an organization for last 10 years and has now going to terminate employment on 15th April 2021 after the code come into force, for past 10 years where you earlier made gratuity provision only basis basic salary, now gratuity will need to be paid on a much higher wage. So it's going to be a significant cost, especially the first year of the implementation.
I think that point really needs an emphasis. So assuming these codes are applicable from April 1st, 2021, you straight away are hit by a retrospective sort of implication, because an employee, as in Puneet's example, leaving on 15th April, if you're going to compute gratuity for that person, you'll have to go back to the new definition of wages and compute a higher gratuity payout than what you may have been providing for.
Yeah.
And also wonder what about companies where there's uncapped gratuity?
Yeah.
They will have a bigger challenge.
Yeah. So I think one immediate recommendation to all such companies where they have uncapped gratuity, please relook at your gratuity policy, because if it is uncapped and calculated on total wages, it's going to be a very significant impact.
Okay, let's move on to ESI.
Yeah. So ESI, currently we know there is a ceiling of 21,000, where employees with salary less than 21,000 are covered under ESI. What they've done under the code, they've not defined the 21,000 cap, and they're saying central government will notify. So most likely if they notify 21,000 or something similar, then employees with wages less than that ceiling are now covered or will be covered under ESI provisions of the code. So not much change. It's just that earlier where we were applying ESI on total wages, because normally under the current ESI law, gross wages are considered. For code purposes, for the code on social security purposes, we'll have to look at employees eligibility basis the new definition of wage. So you'll have to relook at employees who are covered under ESI provisions of the code on social security. That's one. Second, the calculation of ESI. So again, they've not notified the rates. The current rate, which is for employees 0.75% and for employers is 3.25%. Those rates have not been notified in the code. They're again authorizing the central government to notify those rates. So when the rules come out, we'll know what the new rates are. But again, those rates will have to be applied on the new definition of wage. So companies should just relook at the ESI coverage and calculation, where they have to now do these calculation basis the new definition of wage.
So Puneet, are you implying that it's possible that the ESI number of companies covered under ESI may actually shrink?
Yeah, so it could shrink where, so if a final position is performance bonus and some of these variable components are not covered, then yes, it may shrink, because currently for For ESI, gross salary is considered, while now it has to be only wages. But if a position is taken that performance bonus and all these variable payouts are now covered, then it can actually increase. So we'll have to wait and watch how that pans out.
Okay. So in interest of time, keeping this thing going, let's talk about statutory bonus. So the one good thing is that it is express exclusion from the definition of wages.
Yeah, but not so happy news on statutory bonus again. So currently, again, for statutory bonus, under the Payment of Bonus Act, there is a 21,000 cap. Employees with salary lower than 21,000 rupees are eligible under the statutory bonus provisions. The change is, and it's a very important change to note, they now not define the 21,000 cap, and they're saying the cap or the wage ceiling for statutory bonus will again be notified by the appropriate government, which is the state government. Now, if as an organization you have presence in say 10 or 11 states in India, then you'll have 10 or different eligibility limits, or you could have 10 or 15 different eligibility limits for statutory bonus. It's going to be very, very cumbersome to monitor and manage. So that's one part. The second, on the calculation, again, it has to be the new definition of wages. There again, currently under the Payment of Bonus Act, there is a cap of 7,000 rupees or minimum wages, whichever is higher. That bonus is generally calculated on that. Now again, the 7,000 cap has not been defined, and it will be provided by the state government. So I think the biggest implication or biggest issue on statutory bonus as we see it is these limits, both for eligibility and calculation, which are currently there in law. So it's across country, it's one limit. Now will be notified differently by the different state governments, which will really add to the whole compliance issue for any payroll team in an organization.
So every organization will have to look at the eligibility for an employee in a different, lens, in a different lens. Okay, if you move on leave encashment, so current provisions, are applicable to workers. If I look at Section 32 of the Occupational Safety, Health and Working Conditions Code 2020. Provisions relating to eligible leave and leave encashment applicable for a worker who has worked for 180 days or more in a calendar year are, in the Factories Act, we have that 1 day leave for every 20 days of work currently, right? And in under the Factories Act also talks about total number of leaves that may be carried forward to a succeeding year is 30 days. So, and leave encashment, as I understand it, and typically what businesses also look at is when your employment relationship is ending, that's the time to encash leave. Now, what I understand is there is a big change coming on that aspect of leave encashment, and we do have a lot of questions coming in from our attendees today around leave encashment and what's changing in that space. Let's take the audience through that.
Okay. So leave encashment currently is covered under Factories Act and Shops and Establishment Act, and the normal provisions are that you get 1 day leave, like you said, for every 20 days of service, and you carry forward 30 leaves. And normally leave encashment is only available on termination. All of that is the same under the code, Occupational Safety, Health and Working Conditions Code, except one very, very significant change. This is only applicable to workers, right? So the provision on occupational safety relating to leave encashment only applied to workers. So I just want to make that point clear. But the change is that now a worker can encash or can demand from the employer encashment of leave at the end of any year. So if say you have a worker who has 35 days of unavailed leave at the end of calendar year, the worker can choose to carry forward 30 and demand encashment for 5 leaves, or can encash the entire 35 leaves. Earlier, in similar facts, 30 days leaves would carry forward and the 5 days would lapse. But now lapse of leaves may not be an option for workers, especially organization. And this is again applicable not just to factories, across industries. So if you have workers, again, very important to note that there is a significant change on the leave encashment provisions for workers.
And remember, worker is someone who doesn't have any supervisory or managerial duties, not someone necessarily sitting in front of a machine, right? So I think that's the definition we should look at it. And what you are saying is that you cannot set a policy leave encashment saying, okay, carry forward or carry forward not permitted, but you actually have to honor the request of a worker to encash leave in that particular calendar year.
Yes. And then can clients or organizations have two different leave encashment policies, one applicable to worker and other applicable to employees? Again, something to test out for. It is going to be a big change from a leave encashment perspective. Again, the question on what basis do you encash leaves, because the consistent term used across all four codes is wages, and interpretation, at least as of now till further clarity comes in, is that you encash leaves basis the new definition of wages.
Okay, let me just move on to one topic which, and the time's ticking away as very rightly shown by the slide there as well. Is overtime applicable to all employers and all employees? We've traditionally understood overtime to be applicable to only a certain category of employees. Is this changing? And because we've been saying that in our interpretation is maybe there is a unintended outreach of this provision. Can you take us through why we are interpreting it in this manner? And again, I want to point out that this has also been a subject matter of our advocacy, where we pointed out that this could be very, very detrimental to businesses if this was applicable to all employees.
No. So Sonu, maybe before I come to the codes, maybe I take a step back and look at the current laws, because I think that will be very interesting discussion for our audience. If you look at the current laws, there are three laws which talks about overtime provisions. One, the Minimum Wages Act. Second, the Factories Act. And third, the State-Specific Shops and Establishment Act. Now, if you look at all these three acts, most of these state-specific laws and the Minimum Wage Law and the Factories Act do not apply overtime provisions to managerial or supervisory staff, right? So up until now, there was no issue because anyone who's in a managerial role or in a supervisory role there was never any law requiring a company or an organization to pay that employee overtime. So it was settled. The change they've done now is they've brought in provisions relating to working hours and overtime under two of these codes. One under Code on Wages, which I'm again repeating is applicable to all employees. And second under Occupational Safety, Health and Working Conditions Code. And these provisions around working hours and overtime under the Occupational Safety Code are only applicable to workers. Now looking at provisions applicable under Code on Wages, so specifically around working hours and overtime, they start with a clause that these provisions are applicable to an employee whose minimum rate of wages have been fixed under the code. And when we look at the provisions relating to minimum wages, they say no employee should pay any employee wages less than minimum wages, which somewhere we draw an interpretation that it's applicable to not just workers, it's applicable to all employees. And then they go on to say that normal working day will be 8 hours. Employees should be given rest hours of maximum 1 hour in a day. There should be at least 1 day in the week that is off. And then they clarify and emphasize specifically that overtime should be not less than twice the normal pay. So anyone working more than 8 hours will be allowed overtime or should be eligible for overtime at not less than twice the normal pay. And again, I'm stressing that these provisions are applicable to an employee whose minimum rate of wages have been fixed under the code. And if we read the specific provision in the Code on Wages around overtime, they very specifically apply to an employee. In fact, just if I could read that specific provision, Section 5 of the Code on Wages, they start by saying no employer shall pay to any employee wage less than the minimum rate of wages notified by the appropriate government.
So stop here, Puneet. Now, with this specific thing, that they're talking about people to whom minimum wages apply. But then, this is where the linkage sort of needs to be clarified.
Yeah. So I agree, Sonam. It's not absolute clear. It is a big gray right now under the Code on Wages. The big question is if the whole intention was to apply this only to workers, then they had this definition there in the Code on Wages. So all they needed to do was in all these provisions around working hours and overtime, they should have just used the definition of worker, the term worker instead of employee. That's one. The other issue is in the Occupational Safety Code, these provisions have been very specifically made to be applicable to worker. Then why have duplicate laws? If the whole agenda was to avoid multiplicity, why have multiple provisions around that same theme of working hours and overtime in the Code on Wages and the Occupational Safety Code? Code on Occupational Safety Code is very clear, it's applicable to worker. There is no worry and there is no doubt there. But the whole drafting of the Code on Wages around overtime and working hours is a big concern for companies and could lead to unnecessary litigation.
So I think that's where we've also, represented this conflicting provisions should be done away with, and we need to harmonize between Code on Wages and the Occupational Safety, Health and Working Conditions Code. That is important, and we have to keep in mind that all of this will continue to subsist with the Shops and Establishment Act at the state level also.
Yeah.
So that's going to be a challenge if there is, again, whether will this end up being an issue or, reason for clash between center and state. But remember, all of these working hour conditions have always been there in the Shops and Establishment Codes Acts that the respective states have.
So the three laws really now on the working hours and overtime. One, the Code on Wages. Second, the Occupational Safety Code. And third, the state-specific Shops and Establishment Act.
So, if what we are saying is we have to watch out this space. As I said, it could be an interpretation where we are saying overtime is applicable to all, but it should not really be the case. And if there is unintended error, that should be fixed. Because if I look at it in terms of, global best practices, very clearly in countries like Philippines, Brazil, China, South Africa, Canada, France, Japan, where we actually reviewed and looked at their laws, they very clearly say overtime is not applicable for managerial roles. In US, very specifically says it is not at all applicable in case of highly compensated employees. Of course, they define who are highly compensated employees. Brazil says this is not applicable in case of people working from home or teleworking. And China is, again, ahead of the game. They had come out and said very clearly that anyone who works in any other alternate working arrangement other than in the office, sitting in front of the boss, where the boss is sort of seeing how long you're sitting on the chair and how many times you had the trip to the loo, etc. They really clearly got their game together that overtime will not apply to any alternate working arrangement. On a personal side, I think if we get so prescriptive on working hours, it's going to be regressive. And particularly for women, who look forward to the fact of flexibility in working hours and, there's no requirement to keep time, etc. It'll create an onus on the employer to keep track of time and therefore also lead to create challenges for people who will enjoy the benefit of flexible working hours.
I think there the big ask that we have from the government really is to come up with a clear provision and quick clarity on what is the provision, what is it that they're intending to do, and whether overtime really is applicable to all or only workers. I think that still remains. And
removing the multiplicity of these laws from Shops and Establishment Act, etc. So either you say this is clearly covered only under the Central Labor Code and not have an organization go back to the state government to fall in line with the Shops and Establishment Act. Okay, so I think this is another big piece. A lot of the questions coming in and what we've also heard from many of you in our conversations is how is this whole space vis-a-vis employees hired through contractors changing?
Yeah. So what they've done on the whole contractor bit, they have defined three terms really: one of a contract labor, second of a contractor, and third of an employer. Like most part of the definition of contract labor and contractor is same as the current Contract Labor Regulation Act, with one very important change in the contract labor definition. What they're saying is contract labor will be a worker hired in or in connection with the work of establishment by or through a contractor, but does not include, that's the important part, does not include a worker who is regularly employed by the contractor and whose employment is governed by mutually accepted standards of condition of employment. So really, if you have an employment contract from a contractor, then you could not be a contract labor. And who gets periodical increment in pay, social security, and other welfare benefits. So as long as a contract labor or a manpower has these benefits from the contractor, it could very well be a position that the person is not a contract labor. And if that person is not a contract labor, then the person who's supplying that manpower is not the contractor, and then the main entity is not the principal employer. The issue will be the moment any of this condition fails. So if there is no appointment letter, or if the contractor fails to give increment or fails to give any social security or welfare benefit to an employee or to a worker, then that person again falls back in the definition of contract labor. I think there's the big recommendation that again we have for companies is to look at their contracts with the contractors and identify who all will still be contract labor and who all will, for whom they will be responsible as principal employer, because there are, through this new definition of contract labor, there is a possible way out for companies where specifically like for security guard agencies or housekeeping agencies, where you have these employees are regularly employed by these agencies, not specifically hired for the principal employer, there is a possibility for them not to be considered as contract labor and for you not to be considered as the principal employer. But the whole drafting of contracts, the verbiage, the compliances around those contracts will definitely be need to look into. So again,
one clear thing you seem to be suggesting is that whether or not the employees have been expressly hired to work for the organization. So if they had people changing, then these are people in general hired for those services, and they could be changing from time to time. But this is not the only test. I think what we would need to do is actually go back and review all the contracts. So if those of you who have multiple contracts must also start now, because the time to April 21 is short. There will be a requirement to review all these contracts to ensure that there is no liability that is being attracted.
And one reason why it's even more critical, because they just put on additional onus now and responsibilities on principal employer for contract labor. One is that if you have contractor and you have contract labor through the contractor, then the company has to make payment to the contractor before the due date of payment of wages. And under the code, the due date of payment of wages is 7th of the next month, which basically they're trying to say that if the person is the contractor, then irrespective of the credit period you have agreed with the contractor, company now needs to make payment to contractor before 7th of next month. So a lot of additional compliance burden there. Second, if the contractor fails to pay bonus to its employees, to the contract labor, then that onus moves to the principal employer. This is specifically available currently for PF and ESI, not specifically available under the Payment of Bonus Act, now has been extended to bonus provisions also. So as a monthly compliance, one additional check that principal employer should do is whether or not contractor has complied with bonus related provisions, because if the contractor fails, then that onus moves to the principal employer. So contractors and contract employees is one big area of risk, and definitely a lot of work needs to be done there to ensure that organizations remain compliant.
Okay, so this whole we've taken you through the whole gamut of the labor codes. We looked at some of the key aspects. Obviously, given the time, we've not got into a lot more detail, but we've covered several key aspects. What we want to be able to talk about is how is compliance impacted under these codes. Now, what is changing? So the fact is that, the slide seems to suggest that multiple locks have to be opened using these multiple keys.
And you have to identify which key belongs to which lock, because that's the most important part for companies.
Okay, so try and unlock some for us.
Okay, so talking very quickly about some of these compliances, the code on wages, there's a specific provision that company needs to make payment of wages to an employee within 2 working days in case an employee resigns or terminates employment. So irrespective of the reason, company needs to make payment of wages within 2 working days. Could be a big issue. They put in a 50% limit of deduction. So total deductions that an employer can make from employee's salary in a given month cannot exceed 50%, which includes statutory deduction for income tax and PF. So for higher senior level employees where income tax and PF rate is close to 50%, how will an employer recover any kind of advance or any loan will be a big challenge. Then they put in specific conditions for certain type of deduction. So if you say there's, and specifically for absence from duty, so say employee has taken excess leave and you're making a payroll recovery, the company needs to inform inspector cum facilitator within 10 days of making that recovery. So practically every month send details of all leave without pay cases to the inspector. Again, additional compliance burden. If there are unpaid wages, earlier under the state laws, there was a requirement to deposit unpaid wages to the state labor welfare fund. Under some states, now they brought a provision under the central code to say any unpaid wages should be paid to the central labor commissioner within 3 or 6 months.
Which is a conflict between the existing laws. So we have one example where Karnataka and Telangana Labor Welfare Fund Act requires employee to the unpaid accumulation should be paid within 3 years from the date it becomes payable. And here the requirement is only 6 months that is coming in, right? Or 3 or 6 months.
Depending on whether the nomination has been made or not made.
So this again is something that will need to be clarified.
Yeah. And then again, specific formats for registers. So whether an employee master register or wage register every month or a wage slip, they have to find specific formats for that. And they're requiring all employers to maintain these registers in these specific formats. So a lot of additional compliances really.
And I think the point there, we've talked about it earlier, but on the registers and records, because of the data that they want on the wage slip, it could be a gross violation of some of the data privacy provisions as well. I think just in the interest of time, maybe, from Code on Social Security, we've talked about a lot of the stuff that is changing on the Provident Fund side, the fact that we don't know whether the rate of contribution for the employee will continue to be the same, the new category of workers that are coming in, gig workers and platform workers, and Aadhaar to be made mandatory for all Social Security contributions and benefits.
Yeah. So for gig workers, specifically, if you are an aggregator, you have a marketplace where buyers and sellers can meet. Then there is an additional contribution required from an aggregator. The final rate will be notified, but it can be anywhere between 1% to 2% of turnover. So that's again added cost for companies. On Occupational Safety Code, I think we've spoken a lot about it. Basically, what they've done is they've put in additional duties on employer to ensure that employer maintains safe working environment, provide annual health checkup to notified employees, and issue appointment letters to all. And they've made employees auditors. So they're saying if employee comes across any unsafe or unhealthy situation, then employee should report that to the inspector immediately. The first time they're talking of safety and occupational health inspections or surveys, they're talking of safety committee that an employee needs to frame. And there are now special and specific rules around women working in the night shift.
These rules were there in the Shops and Establishment Act, and there was requirement to take approval. But now these are coming in specifically in a central labor code.
And a consistent manner, because currently each state laws define night shift differently. Some states say night shift starts at 9:30, while some states, Karnataka says night shift starts at 8:30. Now at least there is consistency in what is night shift, which is after 7 p.m.
On the next one, the Industrial Relations Code, I think good point to note is that they've reduced the number of authorities you had, the labor courts, etc., to settle industrial disputes.
Yeah.
You're coming in now with clearly for arbitration, there's a conciliation officer and tribunal. So it's 3 levels and it's easier to this thing.
Yeah. They're talking of redressal committees. So they're saying every company or organization, if you have 20 or more workers.
And making it diverse by insisting on women participating.
You need to have a grievance redressal committee.
Yes. So I think well-served and very modern in thinking. They're bringing in a diversity angle here. So that's good.
Yet no provisions for paternity leave. I think I
think you can rest your case. So you look at it. But on the Industrial Relations Code, a new development to be noted is the fact that we are now looking at a reskilling fund. I think this is also a recognition, international best practice and Indian labor codes making a provision that every employer will now have to equip employees with new age skills. And for that, there should be a fund that should be created. And that's how you're getting a reskilling fund that is being done.
So every time a factory or a plantation or a mine retrench employees or worker, in addition to paying retrenchment compensation, the company needs to deposit half month's salary, 15 days wages to the reskilling fund set up by the central government. Standing orders applicable if you have 300 or more workers.
Okay. So one of the things that is really worrisome is, the provisions around non-compliance. While it is good, and one of the objectives of these labor codes was to ensure equity, ensure compliance, and therefore make sure that compliance is the government is in a position to be able to review that compliance is happening as expected. But for non-compliance, some of the provisions that have been provided are worrisome. So first offense, there is a monetary fine that you would pay. But in case of a second offense, now that's where the worry is, because there is no threshold defined in terms of how severe the default is. There is a mere procedural lapse. If there was a return that needed to go at a particular time, it didn't go through, or there was delayed payment to the contractor. There was something that anything which could be considered as unintentional, not intended to in any way exploit the worker. But if there is any kind of such procedural lapse, prosecution proceedings get triggered. I firmly believe that labor laws have to look at equity and they must protect employee rights and workers' rights. but there has to be a balance there. And if you look at the fact that the CII committee expressly in its report had looked at the fact that, increasingly the government should focus on decriminalizing business and economic legislation. And we are seeing this happen in the Companies Act. So, when you look at it, what CII report of February 2020 has, when dealing with these codes, with the labor codes, has said that there are multiple reasons why the economic legislation framework in the country may be decriminalized. And some of these include business and economic laws need not have criminal provisions unless a malified intent or an intent to defraud is found. And because this is also going to impact the ease of doing business in India, and the fact, and it has well recognized and acknowledged, and this is what the CII report also refers to it, that the decriminalization will boost foreign investment in India, because you won't want employers to be constantly looking over their shoulder as to what, could have triggered a prosecution proceeding, especially when you have multi-state presence, large number of employees. An unintended default should not lead to this consequence.
Yeah. What they've also done is, very, very important point is cognizance of an offense. So earlier, if an employee is not satisfied or there is any issue, employee could have only approached the inspector or the commissioner, and the commissioner would handle that issue. And if the issue is severe, then the commissioner has authority to launch claim or launch proceedings in a court. Now, specifically under the Code on Wages, they're allowing a single employee to file a claim before a court, which will mean that an employee is not satisfied or there is an issue. The employee doesn't have to go through the entire machinery of first going to the inspector and then the commissioner. The employee can directly file a claim in a court, which can actually lead to a lot of unnecessary litigation in India, which again goes completely against the whole objective of these labor codes.
And this again, I want to point out that in our representation, we've requested that there be clarity provided on this, and at least prosecution should be by exception. Okay, so what's the suggested way forward for companies? We're sort of coming to the final phase of our presentation. We will try and get into some of these questions, but let's look at what the organizations need to do to sort of leapfrog into a new way of working with the new labor codes. Yeah, you can see the person jumping across, and there are many hurdles on her way to achieving perfection and completing the race, but don't lose heart, we're there to help you. So let's look at what we think you should start looking at. So, you would already got the drift all through this. We've been talking about the need to review existing compensation structure, salary structure for employees, given the change in the definition of wages. How is this going to impact your existing policies and processes? What is it that we are going to do in terms of, keeping time, in terms of working requirements, working day requirements? There are conditions around rest day and making sure that the compensatory rest day happens within 5 days prior or 5 days after. The need to change payroll policies and processes. How do you ensure payment happens within the stipulated time? Deductions don't exceed 50%. How do you connect and coordinate between your payroll and finance? How do you ensure that any recoveries are to be made, and if approvals have to be taken from the inspector cum facilitator, you've gone and taken those approvals, or you've made requisite arrangements for that. If you need to take any approvals from the state government for any particular amenity or benefit, whether that is under process, is there, whether you have that grievance committee in place, whether you ensured women participation in that committee, whether your approvals for getting women to work in night shifts are in place and up to date. How are you going to go about payment of gratuity to fixed-term employees? Are you going to look at provision for gratuity being relooked at in terms of your fixed-term employment contracts? Then the elephant or the big animal in this whole thing is the third-party contracts, because you're also reliant on the third-party employer and whether how the contracts are worded, where you may try to mitigate your principal employer responsibility, yet at the same time, because of insistence and because of the fact that the same employees continue to come and work with you every day under a third-party contract, are you in any way triggering an obligation to take over all the compliance under the labor codes? Then, as every organization, you would want to be able to set up a compliance governance framework around compliance with these labor codes, which would need to be regularly revisited and updated in terms of it. Remember, that these are brand new labor codes. We don't have any judicial history. Even if I said old wine in new bottle, you'll probably have to keep going back to judicial precedents that were there in the previous acts. Yet, how the government intends to enforce and ensure compliance on this is also something that is up in the air right now. Then finally, we've talked all through and all the aspects. You can see very clearly that there are some aspects, even some of these things go away, but some that will stay will clearly have an impact on your profit and loss account. How are you preparing for it? How are you passing on that cost to your end customer? How are you going to communicate those changes to the vendors? How are you going to communicate these changes to employees? So there's lots of work that needs to happen.
So basically six key areas of work that we can really identify that starts now in next 5 months. Companies should really work on this to ensure come that 1st April 2021, companies are ready to ensure compliance with all these various provisions, because non-compliance can be really a big issue under these codes.
So yeah, I think that the thing to sort of get on straight after this presentation is to give us a call and start working on impact assessment, right? So that's what every organization should be looking to do, an impact assessment.
So before the last slide, should we take a few questions maybe? We have some many questions that
okay.
Our participants have asked us. I think one of the questions that maybe I can ask and you can answer: will companies be given transition time when the codes are notified? Will they be given time to transition and work out things, or what should companies be doing?
So my take on this is, in terms of transition time being stipulated in the codes when they are made applicable, I don't think so. But the fact that there is a public debate there is a discussion that's happening. We've had accused, BFM in her stimulus package talked about the labor codes. So these codes have all been out in the public domain. So we can, sort of think that we don't expect a transition time. We should be getting ready for it. So to that extent, treat it as imminent and start preparing for it now. What could happen is, as we've seen all the recent, legislations come out, Companies Act, GST, all of these will be progressive. You could have them evolving, and you could have, phased introduction. So they could introduce some provisions, some could be delayed, etc. So let's start now. My advice is don't wait for the transition time to start working on your impact assessment. It is time to start now.
Yeah, and normally, whenever we see new laws coming out, they would notify on a particular date and then make the law applicable probably 15 days or 30 days later. So it's not as if there's too much time company will be given.
Okay, I think. Do you want to talk a bit about, because a lot of the people who are probably currently kind of entrenched in any kind of 7A proceedings, or those who may be fearing, this thing because it has happened, that people have come in and said, okay, for the last 15 years, you are now kind of covered, and if there's any due, they've gone back to without any limit on the number of years that may be applicable. You want to talk about that?
So I think all these 4 codes have this specific last provision in the codes, where they're saying Section 6 of the General Clauses Act 1897 shall apply. And basically that provision talks about the fact that if a law is repealed, then any existing proceeding or issue or compliance will be dealt with as per that old law. So if you have a PF case ongoing before a PF commissioner where a 7A has already been issued, then that will not be covered under the 5-year limit, because that's a new limit now, and such old notices will continue to become applicable, and companies will have no choice but to defend matters there. So old cases will be governed by old laws. Those may not necessarily get transitioned to the new law.
So one of the questions that I've got is around, whether the EPFO as we know it today will continue as is. Yes, EPFO will continue while they've tried to reduce, as we saw in the labor, litigation and dispute, they've tried to reduce the number of authorities. But in terms of when we look at it from the perspective of whether we will continue to have EPFO as a body that is involved in Provident Fund, yes, that will continue to be there. In fact, if I can actually look up the code, It very clearly says that the social security organization means any of the following organizations established under this code, where you have the Central Board of Trustees of Employees Provident Fund, you have the ESI Corporation, you have the National Social Security Board for Unorganized Workers, there's the State Unorganized Workers Social Security Board, the State Building and Other Construction Workers Welfare Boards, and any other organization or special purpose vehicle that may be declared to be the Social Security organization by the central government. So you see how the theme of equity for all and social security for all is intended to be lived to by creating this whole social security organization structure. And yes, EPFO will continue.
Then there are lots of questions around interns, whether interns are now employees. I think there the definition of employee and both worker are very clear. Only if an apprentice is an apprentice under Apprenticeship Act, then he's or she's not covered as an employee. But in all other cases, if interns are hired or are working like regular employees, then yes, they could be covered as employees, and these provisions can be applied to them also. There are lots of questions around Shops and Establishment Act. I think we've covered that in quite a bit, but the fact is that Shops and Establishment Acts are not getting merged under these codes, and therefore state-specific Shops and Establishment Act will continue to apply. They're not going away. So an organization has to ensure compliance with both the state-specific laws and the new central codes. There are also questions on earlier gratuity was applicable for 5 years and 6 months, whether that 4 years and 6 months, whether that's changed. So no, that's not changed. The gratuity is still applicable after 4 years and 240 days for an employer that's working 6 days, and 4 years and 190 days for an employer that's working 5 days a week.
I think one question, and so the question is, should we wait till states roll out their respective rules before calculating the impact of wages, is very, very pertinent, because I think we have to respect the fact that labor laws are a matter of concurrent list. Both the state as well as the central government have the right to legislate on these laws. The fact is that the central government, once it notifies these laws, these will be laws in enforcement, these laws will be enforced. So we cannot afford not to start complying with this. There may be some select provisions which could require state governments to also make rules. But if supposing you have a situation that national floor wages are notified, and where the government has actually delegated to 2 state governments to notify the wages for minimum wages as well, we'll have no choice but to follow the floor wages that the central government has notified.
Or follow the current minimum wages.
To that. So I think the fact of waiting for state rules, in my view, is not a good way out. You would want to be able to start preparing for it. And, as we know today, it is April 21 that's been declared by the central government. That's when they will put these laws into force, and we will start having to comply with it.
I think, Sonu, if I can add just my 30 seconds to it, it's a journey that any organization will need to take. It's a journey that will start now with that impact assessment study that you've spoken about, and then keep updating that study, keep updating their policy, keep updating their approach, their calculation, their estimates, as and when. So the draft rules come out, and then the final rules come out, and then actually the code become enforceable. So it's a journey that should start now and should continue for next 5 months.
Okay. So let's, we are at the top of the hour. So we are at 3:31. We started a long time ago.
So the last slide now.
So thank you for your patience in listening to this webinar. But friends, picture abhi baki hai. So coming soon are the 3 new draft rules on the 3 new codes. So we will have the draft rules on Code on Social Security. We will have the draft rules on Occupational Safety, Health and Working Conditions Code. And we will have the rules on the Industrial Relations Code 2020. So we shall be back with more, and hopefully we will continue to engage with you in the interim. Stay safe, stay healthy. Look forward to continuing to be engaged with you on this agenda. All the best. Thank you very much.
Thank you so much for attending the seminar today, for the webcast today. Thank you.
Have a great day ahead. Thanks.
Bye-bye.
Bye.